My name is Dave Soren. I am the chair of the Venture Capital and Emerging Growth Company practice at McCarter English. We are a very large, very old law firm, which I love to tell people because it doesn't mean a thing. We're entrepreneurs. Our group are a bunch of entrepreneurial lawyers. I started my career as, actually I should back up. I am a graduate of NYU, yes. The Stern School at the time was called the College of Business and Public Administration. So that tells you something about how long ago it was. When I went to NYU, nobody talked about entrepreneurial activity because the pathways for us were much more certain. You know, you were an accounting major, you went to a big 8 accounting firm. You were a management major or a corp fin major, you went into investment banking, etc. It was all very clear. But that's all over, right? I mean, you guys know that. The traditional career paths no longer exist, and they're not coming back. The future is in innovation, in entrepreneurial activity. That doesn't mean you have to start a company. That's obviously sort of the quintessential way to be an entrepreneur. But even if you join other people's companies, you need to be an entrepreneur of your own career, of your life, and that's how you're going to provide the most value, whether it's to an employer, to a customer, client, etc. So what we wanted to do today was talk about the 5 or 6 key things that you need to think about if you're going to start a company. So how many of you are entrepreneurs already? How many of you have companies? Just a couple of you. How many of you want to be entrepreneurs? Almost everybody. And those of you who didn't raise your hands, what do you do?
Where's the free food?
Where's the free food? I can't tell you. I think there was food outside. Right? There is food out there, isn't there? Yeah, right out there. Free food is almost never as good as you think because the truth is you get what you pay for, right? So anyway, there are 6 things that we want to talk about in terms of the key points of engaging in entrepreneurial activity. The things you really should be thinking about from the time that you first have an idea. And we as Lindsay said, we work with innovators and entrepreneurs literally from ideation to IPO, initial public offering, or merger and acquisition exit strategy, or simply to maturity if the company is just going to continue. So I'm joined by some of my favorite colleagues. Evan Kirsch, who is going to talk to us about some of the formation issues. When you first think about starting an entrepreneurial endeavor, what do? You have to form an entity around it. What should you be thinking about? Jared Soren, yes, same last name. We have the privilege of being related to each other, which is really unusual in the law, but we had very similar interests. He's going to talk a little bit about the intellectual property issues that are critical to entrepreneurial companies. Joe Farino is going to talk about the interchange between protecting your idea and dealing with employees and independent consultants. And then I'm going to talk a little bit about financing related issues. So with that, I'm going to invite you, Evan, to come into the box.
Wow.
And to talk to us all. Oh, by the way, don't hesitate to just ask questions as we're going along. We want to be able to answer the things that you guys are thinking about. And if at the end you have other questions, we're happy to answer those too. Thanks.
Thanks, Dave. As Dave said, my name is Evan Kirsch, and I'm going to start the presentation by talking about legal entities and what legal entities you guys should be thinking about when starting your business. So you have an idea and you're ready to start a business. There are a bunch of different legal entities to choose from. There's sole proprietorships, general partnership, limited partnership, limited liability partnership. And then there's 2 other entities which I'm going to discuss in detail because those are the entities that when clients come to us, we are telling clients that it should be one of these 2 entities. And those entities are a limited liability company or an LLC and a corporation. So I'll start by going through a little bit about a limited liability company. So LLCs are very easy and inexpensive to start. You're pretty much going to take a formation document, either called Certificate of Formation or Articles of Organization. It's about a 2-page document. Fill it out, file it with the state, and if everything comes back all right, you have an LLC. It's that simple. So one of the main reasons, and I'll get this out of the way early, that many people ask us about why they want to, or come to us about why they want to form an LLC, is the tax benefit of an LLC. So an LLC is what we call a tax pass-through entity. So essentially what that means is the company itself isn't taxed, but instead the members who own the company pay the taxes or enjoy the tax loss benefits of the company. So for founders like yourselves, you start a business, early on you're going to have some losses. You can use those losses, those tax losses, to offset any gains you may have in different areas of your life, whether it's a different business or whatever else you have going on. Another advantage of an LLC is they're very flexible in their management structure. So we like to say that LLCs are creatures of contract. And what that means is each state has their own LLC or limited liability act or law, and they're pretty flexible, and they allow founders or owners, or what we also known as members, kind of structure the company the way they choose. Usually when there's more than one member, the members will get together and create a contract known as an operating agreement, and that really sets the structure of the company. Usually there's two types of structures of an LLC, either a member-managed structure or a manager-managed structure. They kind of sound, they are what they kind of sound like. A member-managed LLC is the members, they kind of make a decision when there's a business decision to be made. And a manager-managed LLC, the members or the owners, they elect managers to run the daily aspects and make the decisions for the business. There are some different aspects in terms of voting structure, but that's a little more detailed than we need for right now. But if you have questions, feel free to ask. So there are some downsides to forming an LLC. The biggest one that we see in terms of forming an LLC is if you want to go out and raise money for your company down the road from sophisticated investors such as venture funds or angel investors. They really frown upon and tend not to invest in LLCs and prefer to invest in corporations, mainly for the reason that I discussed before, that tax pass-through. They don't want to deal with the tax pass-through and have to deal with the taxes if there's a gain or a loss. They'd rather the corporation deal with the taxes, and they can just hang out in the wind. Also, unlike a corporation, an LLC can't issue incentive stock options. I believe it's Joe's going to talk about these more in detail, but for now, an incentive stock option, you want to incentivize employees, you give them stock options. Incentive stock options have tax benefits, and LLCs can't issue those. There's one other downside to LLC that Jared had reminded me about before. There's something called the qualified small business tax benefit, that if you invest in a small business and you hold this, and it has to be stock. So LLC doesn't give out stock, they give out membership interest, so it has to be stock. You hold the stock for 5 years or longer, you pay the taxes when you sell your stock. The taxes you pay are very much lower, more like what is it again?
Basically tax-free.
It's basically tax-free, so that's a great benefit of a corporation. So one other thing to recognize about an LLC is if you do, you see like you want to form an LLC, you feel like you want to form an LLC for the tax benefits, you can always switch to a corporation down the road. So a rule of thumb that we like to use is if you're going to be looking for financing in the next year, a corporation, then you should be looking at a corporation, not an LLC. If you're not going to be looking for financing for at least a year, then we'll look into other details of what you're looking for, but an LLC may be an option. So now we spent a little time on LLCs. Let's move on to corporations, which are the more customary type of business entity. They're a bit more expensive to form. You have to file a certificate of incorporation in the state in which you want to be formed, and there's a little more meat to a certificate of incorporation. There's a little more paperwork that's involved, so they become a little more expensive. Also, there's two types of corporations. There's a C corporation and an S corporation. The difference between a C corporation and an S corporation is the S corporation, like a limited liability company, is a tax pass-through entity, so you can enjoy the same tax benefits of an LLC. And the way that would work is you would form a C corporation and you would fill out what's called an S election form with the IRS and set up and would become an S corporation. But there are some requirements and some restrictions on that. Like who can be a stockholder. For example, non-resident aliens may not own stock in an S corporation. The number of stockholders is limited to 100. Once you go over 100, you can't have an S corporation, and you may only issue one type of stock. So if you want to do if you want to bring on investors, and you want to issue them preferred stock with additional rights, you can't have an S corporation. So essentially, if you have an S corporation and you break any of these rules or restrictions, what we say is the S corporation busts automatically, and you go back to being a C corp. So it's really not that big of a deal. Or you can always elect to go back to being a C corp at any time. So there are benefits. It's just a matter of weighing the benefits with where you are in your business life cycle. Some other things to keep in mind about a corporation. An LLC, like I said before, is a creature of contract. There's a lot more laws that kind of lay out how a corporation has to be run. For example, the management structure is much more already laid out. You have to have your board of directors who kind of run the high-level aspects of the business. They bring in the officers, like the C-suite, like the CEO, to run the day-to-day business. And then the board oversees the officers, kind of has to be okay on a lot of different things that the corporation might want to do, like financing or give out stock options. And then there's also the stockholders who elect the board, and on top of that, they also have to, anytime the company wants to do like a bigger company transaction, sell the company or do a financing, they also have to approve those types of transactions. So that's a little bit of a background on LLCs and corporations. Now, a couple other points to hit on. Why form one of these entities, and why an LLC or a corporation as opposed to some of the other entities I discussed earlier. Well, forming a legal entity is important for entrepreneurs like yourselves because you want to protect yourselves from personal liability. So if something happens in the business, the business owes money, has debt, or someone sues the business, you want to protect your personal assets if someone comes after the company. And a legal entity is the way to do that. So you may ask, okay, so when's the right time to form a legal entity? When do I need that type of protection? We like to say anytime you're going to start dealing with a third party, you're going to bring on an employer, you're going to sign some type of business contract, you shouldn't personally sign that, you should sign that on behalf of the company. So that would be a good time to form your business entity. But there are some caveats to this. So, for example, you form an entity, you form a corporation, you're protected, you insulate yourself from personal liability, but you decide that you're going to set up one bank account for the business and pay your mortgage through that. Well, now you're kind of commingling your company assets and your business assets, and the court may say, well, they're not separate legal entities, and if someone comes after you, they may be able to come after your personal assets. Another example of this is you fail to follow a lot of the corporate rules and regulations, like have stockholder meetings, elect a board of directors, elect officers. These are things that you need to do to show that you're running a corporation and you're just not using that corporation in other ways. Another question that we get a lot is, where should I form my entity? And most people will tell you to form your entity in Delaware. And there are reasons for that. We just don't throw Delaware out there, and people don't just form in Delaware because lawyers say so. The corporate law and expertise in Delaware, there's extensive precedent in corporate law down there, so it's kind of predictable. Lawyers can kind of tend to understand which way they're going to come out because of the history of corporate law and decisions. It's just easier for lawyers, but more importantly for entrepreneurs to think about is when you go out for investments from, like I said before, venture capitals and angels, they want to know that you're a Delaware corporation. Because they understand corporate law, they're comfortable with it. There's other states out there that have copied Delaware law, but at the end of the day, venture capitalists and other investors, they're comfortable with Delaware law. In terms of an LLC, it matters less where you form your LLC than your corporation. That said, if you form your LLC knowing that in a year you want to flip to a corporation, there's a cost to that, but it's easier and less expensive if you're already a Delaware LLC. And then the final point that I'm going to hit on today is this idea of good housekeeping, good corporate housekeeping. And what I mean by that is, after you form your corporation, you kind of want to make sure that you're keeping good records, you're keeping minutes, and you're keeping any contracts that you have. You want to keep that in good order, whether it's you keep a binder of all your records, or now there's something called e-shares online that'll keep track of stock options and stock awards that you hand out. It's important that you keep track of this stuff from day one and keep everything in order, because when you go out for financing or you go out to sell your business, the investors or the purchasers, they're going to want to do their due diligence on your company. If you have a binder, you have everything already ready, it's easy to just hand them this. They can go through it and say if something's missing or if there's a problem, it's easier to fix than if everything's all over the place, you're a mess, and then an investor comes back and there's deal fatigue, and then all of a sudden they're like, well, if you can't keep track of your corporate records, why would I want to invest in you? We see problems like that quite often. So it's easier to get into good habits earlier and start now than have those type of problems down the road. So with that, I think Jared's up next.
Any questions for Evan before Jared comes up?
Yeah. Can you give a rough estimation? How much can it cost to set up an LLC in Delaware and to register it in New York State?
Well, so there's the process of actually like filing or setting up the LLC. That's pretty easy, but the filing fees, they could be a couple $100
Per
so,
state, yeah.
So it depends on the state. Each state has different rules. New York has like a requirement that after you form your LLC, you have to go out and publish, and that can cost another $1,000 to $1,500. You have to publish in newspapers. And each state has their own requirements because they're all state laws that govern the LLC. So it depends on the state really.
But to operate in New York State, you must register it in New York State, even if it's Delaware.
Yes.
LLC.
You saw about certificate of authority.
Okay, so yeah, so if you form in Delaware and then you're doing business in New York, yes, you have to file a certificate of authority, it's called, and then I think there's a publishing requirement for that as well.
You mentioned briefly about S Corp. What's the benefit compared to a C Corp?
So the benefit of the S corporation is it gives you the same tax pass-through effect that a limited liability company gives you. So if pretty much if the company has a loss early on, those tax losses can pass through to you personally, and you can use those losses to offset any other gains that you may have. If this is just you're doing this on the side to start, and you have gains in other areas. So it's a nice benefit to have. Yeah.
Go ahead. I actually have an S Corp that was elected by the IRS, so I'm wondering if to the conversion from S to C Corp, would that be an FT process, or can I do that on my own? Or?
I think it's just another form. It's like you filled out the form to elect to be a S corporation. I think if you want to go back to a C Corp, it's a similar form that you just file with the IRS once again, and then you start filing taxes like a C Corp. I think that there.
So what would you suggest for a foreigner who wants to form a company in the United States, just because based on their target audience it's mostly focused in the United States? What would you suggest?
Well, there's other rules in terms of what your status is in the country, whether or not you can form an LLC or a corporation. I'm not 100% familiar with those rules. We have employment lawyers who are always happy to work with us. I believe Amy,
Amy our immigration group.
she's always happy to work with us, and she has her immigration group, so she's better at those type of questions. I don't know, you may have better answers than I do.
I don't. It's a good question, but if you are, you'd have to look at the status that you have. Let me stand up. You have to look at the status that you have here, whether or not you can even be an officer or a director of a new entity. So you'd want to make sure that you're not violating your own immigration status. Someone like Amy Haberman, who heads our immigration law practice, can answer those questions really easily. But other than that, if you are here and you are subject to U.S. tax law, whether you do a corporation or an LLC, doesn't matter. It'll be the same as if you were a U.S. citizen, for example, because it's simply a matter of whether or not you're subject to paying taxes here. The other thing is, as Evan said, if you're a non-resident alien, you cannot own an S Corp. And so if you want the tax pass-through element that he was talking about, then you have to be an LLC. And the qualified small business stock issue is really critical. It's something that people didn't really start talking about until the last year or so. There's a 5-year holding period. And so if you want to get the benefit of qualified small business stock exclusion, which basically means you can get your gains tax-free, okay, this is big, then you want to get that, presumably you want to get that clock ticking as early as possible. And so unless you're going to have a real benefit from an LLC with the tax losses that might pass through to you, you want to weigh that against what is the potential benefit of tax-free gains if this company is likely to sell in 5 or 6 years, right? So that's a really important consideration. When we talk about financing, we'll talk a little bit about that as well, because it really impacts what type of financing vehicle you might want to use. You guys as founders don't really have that issue, because if you're a founder and you own stock in a C Corp, it triggers immediately. So this is not just for investors. People who form companies can get the benefit of a qualified small business stock exclusion. It's really important. This is something that really started back after the financial collapse and deep recession in the United States. Our legislators were looking for ways to motivate investment in small businesses. To be a qualified small business, you have to have less than $50 million in assets. So it's small businesses, really startup type companies. The law, though, used to die of its own volition every December 31. So there was no certainty for investors or founders as to whether or not they would continue to get these benefits. And I think it was at the beginning of 2016 or late 2015, Congress finally made this a permanent part of the tax code. It was a really important consideration. And again, we're going to talk about it when we talk about financing. It is changing the methods being used by investors to invest in companies. You know, you probably have all heard about convertible notes and safes and kisses. None of those securities qualify for the QSBS exclusion. So, and they don't qualify toward the holding period. So as a result of this becoming a permanent part of the tax code, we're seeing investors really changing their view on what type of investment vehicle they want when they invest in you guys. And that's really important to know. But we'll talk more about that when we talk about funding.
Anyone else?
Now, I want to know more about like how easy or difficult it is to add another person to an LLC, or like changing the operating agreement and amending. Is that a simple process?
Well, usually it's like I said, it's a feature of contract. So the contract or the operating agreement itself usually has thresholds that you need to meet in order to amend the operating agreement. So if it's you and one other person right now, odds are you both need to sign it to say we want to amend it, and you can amend it to bring that third party in, and then they have to sign to become a party to that agreement. If it's depending on if it's member managed, you know, how many votes you need, it just really comes down to the contract itself, what it says. All right. Anyone else? That's it.
Thanks, Evan.
Hey everyone, I'm Jared Soren. I'm going to be talking about the second legal issue, which is how do you protect your intellectual property. So outside of you guys, the founders of these companies, intellectual property is generally the most valuable asset that you guys have. So obviously it's important to protect the things that we create or the inventions and ideas that we have. So when people think about protecting their IP, the general thought is patent, right? How can I patent this? But the reality is that patents are not the only option, and oftentimes are not even the appropriate option to that technology, so long as nobody else independently creates it, or it gets leaked. So those are some of the standard other types of IP protection that we see, but there's way more than that as well. In terms of why do we protect our intellectual property, for one, Evan mentioned the importance of investors. Investors are going to want to see that the company owns the rights to whatever it purports to create. And if there are others who have the access to that technology or can do what you do, it is a disincentive for investors to invest in your company. So obviously, we want to build the value of the company within the four walls of the company. So protecting the IP to prevent others from doing the same thing is important. It also deters others from stealing your ideas or maybe even entering the market that you're in. So if others see that you have a patent as to a technology that they're considering getting involved in, that just may be a disincentive for them to not even start their business to begin with. And then another one is that the company may go on to sell at some point. Potential acquirers, like Evan said, are going to do their due diligence on the company. They're going to want to see every document that you guys ever signed showing the protection of your intellectual property. And we don't always like to talk about horror stories, but there are many when it comes to protecting your IP and potential acquirers. We represented a company who was looking to sell their company. We didn't represent them before the sale, which I like to disclaim. And so this company had made the affirmative decision to never look for invention assignment agreements, which I'll talk about in a second, from their employees or their consultants. It was an awkward conversation that they didn't want to have. And so a potential acquirer comes in for many millions of dollars and says, I'm doing my due diligence, show me that binder that Evan talked about with all the documents, all the invention assignment agreements. An invention assignment agreement basically assigns all of the creations that an employee or consultant make to the company, so that the company is the sole owner of the inventions. And the company said, well, I can't do that, I don't have one. And so the acquirer said, then we don't have a deal. And essentially basically said, go out and get those invention assignment agreements from every current and former employee and consultant. And if you can't do that, then the deal's off. And so you can imagine a situation where people, this is now an established company, it's been in operations for 6 or 7 years. You can imagine that there are former employees who left and are either on bad terms maybe, or have no incentive to sign one of these documents. So they had to pay them a lot of money. And the company still did very well, but they paid a pretty penny for invention assignments to be signed by all their employees and consultants. So that's pretty important. Acquirers may totally say no deal, like in that situation, or they may lower the purchase price, depending on the risk that they're willing to take. So a well thought out IP strategy is, unfortunately, you can't use that intellectual property. You could potentially go and seek a license from them, which may be valuable if you're doing something different than them, but frankly, a competitor is not going to give you a license to do the same thing that they do. So if, like, let's say you have a completely different application for it, they might, you'd probably have to pay them again once in equity probably, to license that technology to your company for the sole use